All rise. Puis vous lever. The International Criminal Court is now in session. L'audience à la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please call the case.
Thank you, Mr. President. Situation in the Republic of Kenya in the case of the prosecutor versus William Samuel Ruto and Joshua Arap Sang, ICC 01090111. And we're in open session, Your Honor.
Thank you very much. Are there any changes in appearances?
Good morning, Your Honours. Yes, for the prosecution, we're the same except Mr. Garcia and Ms. Sims are absent this morning.
Good morning, Mr. President, Your Honours. For the victims, we remain the same. Thank you.
Good morning, Your Honours. For Mr. Sang, the team remains the same. Thank you.
We're the same, other than Data Alexander, who's now here. Thank you.
All right. We will then continue. Witness, welcome back. Thanks for joining us again. Yesterday there was that suggestion that whether to have the defense conduct their cross-examination and then we'll return to document. We will not proceed in that way. We will proceed in the usual manner. A witness will bear with us and sit there. This is one witness whom I'm sure does not feel uncomfortable in the courtroom and around lawyers. So he can sit and we will proceed as normal. Thank you.
That's true, Mr. President. Thank you.
Ms. Zago.
Thank you, Mr. President. Good morning, Your Honours. I can inform the Chamber that the prosecution intends to tender only 2 other documents to this witness, which are contested. The remaining documents, the prosecution seek to be granted an MFI, and the remaining 2 documents, which are tab 5 and 6, the prosecution does not no longer intend to seek them through this witness. Therefore, the examination in chief might be shorter than expected.
Then you said that there are 2 documents you still want to tender through the witness. Is that it?
Yes.
All right. Let's get to those then.
Certainly. The first document can be found at tab 4 of the OTP bundle, and the ERN number for display to the witness only, given the confidentiality of the information contained therein. And the ERN number is CAN OTP 00020015. As I said, the content is confidential, and we would request that the public does not have access to this document on their screens or monitors. Thank you. Your Honours, this is a compilation of contemporaneous situation reports by the Kenya National Security Intelligence Services, the NSIS, so-called NSIS, that cover a period from June 2007 up to February 2008. The reports are collated in one single ledger.
Before we go there, does the defense contest that characterization of the report in terms of the source of it?
Yes. No, we don't contest.
You do not contest,
don't contest the nomination, as it were, of what it is, and its specific paragraphs that my friend's been good enough to indicate to us yesterday, about a dozen paragraphs out of about 200 that are being sought to be put in. Now, in respect of those paragraphs, when we say we see no reason, if they're admitted, why they should remain confidential, but how that process is engineered, if the court were to consider that they shouldn't be confidential at this stage, I'm not going to suggest. And in respect of the nominated paragraphs, we have no, for our part, any essential objection, bearing in mind your decision of last week with other NSIS reports, where you said that you found them prima facie relevant. It relies on unverified sources or predictions. The probative value may become outweighed by prejudice if relied upon to prove central aspects of the charges, such as common plan, systematic nature of attacks, or existence of network. But it was all right, you felt, to use it as general background information as to widespread nature of attacks, election campaign activity, and what was being reported at the time.
One second, you may be jumping the
Yeah.
gun. What I wanted to know now from you was whether there's a need to have this witness speak to the document in terms of, is this National Intelligence Security Agency report received by the CPAV or not? You're saying there's no need.
No, we've accepted that he's been shown this last week, and he's recognised it as material that came before CPAV.
Good. So that's all I wanted to know from you for now. The prosecution will later on tell us what they want to do with it. But, Mr. Keegan-Kappa?
Mr. President, we take the same position. We do not contest. We will, however, in terms of production, we have a few observations to make. Thank you.
Thank you, Your Honor. As I was indicated before, this collection of situation reports is organized in reverse chronological orders. So if Your Honors intended to browse this document during the legal arguments, I would advise to commence from the back of the document and come to the front in terms of following chronologically the assemblage of the documents.
Now, is there a need then to still leave the blinds down if the witness is not going to talk about the document, or are you intending to show the witness parts of the document?
In light of Mr. Hooper's comment, we do not intend to show the witnesses the specific paragraphs. I note that this document was classified by the NSIS as secret, and this is the reason why the prosecution intended to display it only in the courtroom. And also, my understanding is that the report was received confidentially during a confidential hearing from CPAV.
So what you're saying is from time to time you may be taking us to, you may be pulling up parts of this document on the screen.
I don't think, in light of Mr. Hooper's comment, that that will be necessary. I was providing further information on our course of action.
So the blinds behind the witness can go up. You have indicated, I've learned from Mr. Hooper, certain parts of the document you're interested in. Can you put those parts on the record?
Certainly, Your Honor. Starting from page, and again, I'm following a chronological order. Page 0097, paragraph 422. Page...
Sorry, that's not on our list of nominated paragraphs to be relied on. I'd have to look it up.
I can return to that paragraph. It's a discrete paragraph. In case there are objections on the other side, we can revisit.
Well, you've given me the page, but not the paragraph. Could you perhaps indicate the paragraph? Oh, did you give the paragraph?
422, she
Thank
said.
you very much. I'll just read it. Thank you.
All right. Just give us the paragraphs you're interested in, and if Council want to make any observation later during that turn, including that you may have indicated additional parts that you had not given to them before, they can do that later.
We've no objection to that particular paragraph.
Thank you. The following paragraph is 383 at page 0087. Paragraph 349 at page 0075. I should mention that in this page, there is, under paragraph 349, there is a first bullet point. The paragraph that is attached to that bullet point, we intend to rely upon. And in the sixth bullet point on page 0077, it is still under the same paragraph, and it's the sixth bullet point from the top at page 0077. Paragraph 341.
All right, let's go in a certain order. If you're going to say page first, paragraph later, let's follow that, instead of reversing it all the time. So let's do page first and then paragraph. So what page next? I've got on my notes 0077. What is the next page?
Next page is 0073.
Okay.
Paragraph 341.
Right.
Up to the first paragraph at page 0074.
Excuse me?
Yes.
I think that's a mistake. You said paragraph 341. In my notes, this is 0072 to 0073. Right?
Okay, let's get to that page. Ms. Zago, do you see the difficulty?
Thank you for the correction. Appreciate. It is page 0072, paragraph 341. Page 0073, the first paragraph that starts with the words Transzoia. Page 0071, paragraphs 392, 329, 333, 335, and 336.
Now, is there a correction there on the record? So, is it 392 or 329?
329.
So, you are not relying on 392, although I notice there is no 392 on this page.
That is correct. Thank you, Your Honor. Page 0060, paragraph 270. Page 0059, paragraph 265. Page 0051, paragraph 215. Page 0050, paragraph 209. Page 0048, paragraph 192. And finally, page 0020, paragraph 40. And I can advise the defense that we no longer seek to rely upon page 0087, paragraph 384, as it was indicated in our email to the defense yesterday. While the prosecution seeks to tender this document, rely upon the selected paragraphs, we intend to seek the entirety of the document in light of Your Honour's decision that in order to assess in the proper context the content of the document, the probative value of the document, and the information contained therein, and all other indicia of reliability that might be found in the report, we tender to seek the report in its entirety, however, to rely upon the selected paragraphs for background purposes. Those paragraphs are related to matters before the Chamber. They deal with the widespread and systematic nature of the attacks against civilian population, in particular perceived or actual PNU supporters in the relevant areas, more generally in the Rift Valley. They provide information that, I should add, is contemporaneous. The reports are dated, and the reports are ostensibly drafted in the ordinary course of business by NSIS agents in the field, providing information to their chain of command.
That, of course, is your submission.
Excuse me.
That can only be your submission, that the report was drafted in the ordinary course of business.
On its face, it would appear.
What I mean is that we don't have evidence of that. We have document for what it says. Yes.
As indicated previously, this chamber has already analyzed a considerable set of documents that were produced before CPEV by various intelligence sources, including the NSIS. The documents were admitted by Your Honours for the specific purpose of providing background information on, again, the widespread nature of the violence, the election campaign activity, and the nature of what was reported at the time. These documents, contrary to other intelligence reports that were admitted, do not comprise opinions or analysis by the authors. They're merely accounts of events during the relevant period. They are dated and have a serial number. As indicated before, the fact that sources are not identified has not prevented the Chamber from accepting similar documents, precisely because the documents are not to be relied upon in a direct manner for central aspects of the case. The documents or several reports, CTREP reports, that are included in this collection do mention the accused. However, the prosecution has carved out those paragraphs directly mentioning the accused and their alleged involvement. Therefore, we do not intend to rely at all upon those sections. We believe that these documents satisfy the minimum requirement for admission they are related to the charges. They're prima facie relevant. They have indicia of reliability. And bearing in mind the specific and limited purpose for which this report is tendered, the prejudice to the defense in our submission is minimal, and the documents should be admitted. The admission of the document per se will not prevent the Chamber from exercising its fact-finding functions. The Chamber will be able to evaluate the document at the end of the case against all the other evidence that will have be admitted and presented before the court. Therefore, in terms of weight, that exercise will be conducted at the end against the rest of the evidence that will be before the Chamber. This concludes our submission on this specific document. Again, the prosecution seeks to tender it for background purposes. Thank you, Your Honors.
Mr. Keegan-Cartwell.
With your leave, Mr. President, I will request my colleague, Dr. Buisman, to proceed.
Ms. Bausman.
Good morning, Mr. President, Your Honors. On the basis of your decision and on the basis of what my learned colleague said, with the limited acceptance or admissibility to the sole purpose of the general background information, we may not object, but I do want to make a few observations. And I'm looking at your own decision. This is again 1353 at paragraph 50, where you refer to...
before you say that, let's first of all get clearly on the record what you're saying. You're saying you are not objecting, but you want to put certain observations on the record.
Indeed. I just want to be sure that we are clear on the scope of the admissibility, and but in particular because I heard my learned colleagues say we have omitted all references directly relating to the accused, but there's still references to planning, and planning goes to common plan. And in paragraph 50 of your decision, you refer to the central aspects of the charges, such as the existence of a common plan, the systematic nature of attacks, or the implication of members of the alleged network. That any of these documents, given that there's no signature, there's no official stamp, we don't know anything about the sources, we do not know if it's hearsay, double hearsay, triple hearsay, or even further remote hearsay. So on that basis, I mean, if you want, I can go through the paragraphs. Some of them do not relate to the temporary scope of the document containing the charges, which is, in our view, not very relevant, and those that do relate to the document containing the charges. Yeah, as I said, given that you've already ruled upon this, in light of your decision, we see little scope to object, but we do want to make sure that when references are made to planning, this solely goes to background information, and it cannot be relied upon to show the existence of a common plan.
Have we already ruled on this particular document?
Not this particular document, but very similar documents, the NSIS documents for instance, KEN OTP 0008-0180.
It may be safer for you and your colleagues to assume that the rulings we made were rulings made to the particular documents that we were looking at the time we made the ruling, if you want to, of course you're free to argue that there's some similarities that should apply, but it is not safe to say because we made a ruling in relation to document X, that ruling always necessarily applies to document B, although they may come from the same pool or the same batch. So the point is, you can speak to the prosecutor's offer that their purpose in tendering this document is for background information only. As I understand them, that they do not intend to implicate the accused persons directly with information seen in this document. Now, later on, of course, they will tell us whether they also what it say in reaction to your observation about planning. They will react to that when their turn comes. But the point is, speak only in terms of the background and then your concern about incriminating material, and not rely on the rulings it made before, as if it automatically applies to this document.
Mr. President, I appreciate it doesn't automatically apply, but if I may read out your analysis here at paragraph 50, you find the document is prima facie irrelevant to the questions, but you are mindful of the nature of such intelligence documents. So in general, you make a general observation about intelligence documents which rely on unverified anonymous sources and often contain predictions rather than accounts of events that have actually occurred. And if we look at this document, it's entirely, the sources are entirely anonymous. We have no idea where this information comes from. And as I said earlier, it could be 5 times hearsay. We are unaware of the document. So we do think, though I appreciate what you're saying, we do think that the same analysis applies. And also, as my learned colleague limited herself to general background, I just want to make sure that we're not bringing in evidence about a common plan through a back door, because if that's the situation, then we would object.
Mr. Hooper?
Yes, I can merely echo what Ms. Busman has submitted and adopted. Indeed, in dealing with, and I think we can speak of a class of document here in these NSIS reports that's already been touched upon in respect of paragraph 50 of your decision. And in the bar table objections to NSIS reports, this defence raised a document. I'll give its nomination, but it needn't be called up. It's document KEN-OTP 0006-0048, which we submitted is important to a proper understanding and appreciation of NSIS documents, because it's the NSIS Director, General Gichangi, who explains that the security briefs contain unverified intelligence which must be verified by other security agencies. Let me start again. He says the briefs contain, quote, unverified intelligence which must be verified by other security agencies and subjected to further analysis, unquote. There's quite a considerable step between this kind of anonymized information from unknown sources, of course, to evidence. The prosecution relying on this material as evidence of proof of the truth of the content. And we'd submit that's a very dangerous thing to do with this kind of material.
Mr. Hooper, let me stop you there. You said you were adopting Ms. Bousman's position, that was your starting point. And her position was that to the extent that the prosecutor is going to rely only on the parts they have indicated, and to rely on those parts only for purposes of background information, that they do not object, say, the Sang defense, but that they do object if inferences of guilt may be drawn from those parts. That is my understanding of that position. Is that yours too?
It is, with a nuance, which I'll come to in a moment. We've no objection to it being used as background material. Well, what is undefined is what is background. A particular problem that we have with this material, it's a compilation dated July 2008, and it's compiled as a presentation to SIPEV. And given the history that you already know about the forces, if I can put it like that may be in existence, the interests that may have been seeking to protect themselves, or perhaps prejudice others at that time.
We don't know anything of that sort. We are only operating now. We have evidence of what you're saying and what the prosecutor is saying.
Indeed, but this will probably be developed in the course of the case. But the position is, but even this is subject to an obvious concern and hesitation on the part of us to accept the reliability of these matters, and the fact that it then becomes labelled background still requires great care and hesitation in approaching this material. So there's a nuance. The courts accepted NSIS reports with considerable limitations imposed on that material. In respect of these particular reports, you'll see they work, as we know, from back to front. The working from front to back in the normal manner in the bundle, you'll see that many of the reports, or several of the references that my friends referred to, are way outside the temporal interests of the court, and as far as background is concerned, they far exceed what one might have thought reasonably was background to this case, because it projects way into the future, into February, late January of 2008. But there is particular concern that we'd raise in respect of paragraph 329 onward. And if we turn to page to 329, that's on page 57 of the document, which is 0071 on the ERN. Now, this is a situation report for the 4th of January 2008. And of particular concern here, and this extends to the subsequent paragraphs, that's 335, 336, which are the others that have been itemized here.
Mr. Hooper, so we can cut the process of your submission short and go to other things. You referred to paragraph 329, did you? Okay.
I'm looking at paragraph.
All right. Right. 1 second.
In other words, the matters that have been identified.
Mr. Hooper, 1 second. Paragraph 329, for example, we have the passage saying allegedly intent. Is it the sort of thing we have in the other ones that should cause you worry? That somebody wrote and said somebody else allegedly saying something. The point is, you made your point that you do not accept this material be used to draw any inference of guilt against your client. I think that should be enough, don't you?
It goes a little bit further than that. I mean, what is background material? If it's something that directly concerns the substance of the case, the question of network, for example, the question of organisation of militia groups, organisation, that kind of thing, that touches upon the case. That's evidence that we are concerned about. It really comes to this, doesn't it, really? If background is material that doesn't impinge on the case, is truly background, then we would have no objection to it, because it wouldn't directly concern us. I say directly concern us. But when you've got this kind of observation at 329, when you've got the kind of thing at 333, when you've got the observation of a chief Rukua at 335, going around identifying houses. We object. We're unhappy. It's not a question of being happy or unhappy. It's wholly inappropriate.
Well, what passages do you object to?
Well, I think we can easily deal with that by saying you'll see that those paragraphs all relate to an alleged situation report for the 4th of January 2008. We don't accept, by the way, that these are genuine documents in the sense that they've been honestly compiled. That's at root. And of interest is that in Kenya too, the prosecution in respect of similar intelligence have said it's unreliable. They're wearing different clothes depending which case they're in. But in respect of this, we'd say that it would be wrong for the prosecution...
Did you say the prosecutor in another case said that the intelligence reports are unreliable?
This prosecutor, OTP, in Kenya too, has said that the NASAC reports, which is part of the intelligence community in Kenya, the NSAC, of which NSIS, as I understand it, forms part, is producing reports that are unreliable, slanted.
All right. Ms. Zagel, of course, will speak to that when it's our time.
Yes. But yes, I can give a reference to that if my friend wishes. But coming back to this particular document, 4th of January 2008. So we've got specific factual allegations, absolutely central to the case. Not general background. This is activity at the time. And we say, you know, given the background, the potential background to this material, all the rest of it, the anonymous nature of it, the possible slant, all the rest of it, it would be wrong, procedurally wrong, to permit the prosecution to rely on these as fact. And the same applies for the next report, which is the situation report to the 3rd of January.
What page are you looking at?
This is the next page. So we're now, it's because the dates are going backwards, we've moved from the 4th of January to the 3rd of January, 08 reports. And what one has there at paragraph 341, and it's paragraph 341 you may recall is being referred to or relied upon up until the end of the first paragraph at page 59. In other words, just over the top to the top of the next page, that first paragraph is the limit of what my friends are relying on there. And what do we have here? We see Kalenjin youth in using it, planning to raid, burn houses. Then we've got names of people, tender rate houses, speculation Kikuyu, Feridman Giki, and then some ODM leaders allegedly gave money to Kalenjin youth. This isn't background material. As a prosecutor, if you have this kind of material, you perhaps can use it as a springboard in order to seek out those informants and produce the evidence. But you don't limply, in our submission, introduce this kind of material, call it background material, and clothe it in that manner, and necessarily put the defence's mind at ease that it might not have some other purpose in being introduced. And if we go on to the next report, which is relied on, it's the 2nd of January, that's page 61 of the document, at paragraph 349. I lost track, actually, exactly what part of that was being referred to by my friend. 349, as you'll see, extends over almost 3 pages. And some of it clearly relates to areas that we're not concerned with, though, of course, those are areas that may be of interest to you, the judges, as background material. That's exactly the kind of material that we thought these reports, if they're going to be looked at, might be looked at for what's going on in Nairobi and Mombasa and the other contemporaneous outbreaks of violence. But it seems that this prosecution is looking rather more focusedly on facts concerning Eldoret and Uasin-Gishu. And again, as for the previous 2 days of reports, there is concern, an objection in respect of reliance on that other than background. But what is background? So anything in part of that extends to substantive issues in the case, and it's quite clear they do, shouldn't be relied on in our submission. In other words, if the prosecution is saying this is background material, then it must be understood that that is all it is, and not of the quality that I've just highlighted. It becomes perhaps less significant as we go further on in time, back into November, and so there's no reports here of political meetings or of hate speech by Mr. Ruto, for example, in political meetings, but it's still of concern that there's material here that might be pieced together by a prosecutor later to try and indicate network or the other features that you know are matters that need to be shown evidentially in this case. If that is being used evidentially in that way, then we have a concern with this document. And those are our submissions.
Ms. Zago, any one specific question? Of course, you may speak to other things that your colleagues have said. What a number of issues that spring to mind. One is planning. Are you going to use this material to argue planning?
There is a distinction to be made between common plan and planning of the attacks. In paragraph, and I understand Your Honour's direction that each document should be analysed individually and scrutinised separately from the others. But paragraph 50...
But there will still be some general principles to keep in mind. If, yes, that is correct. But if certain principles have been indicated, it's also safe for you to keep that in mind, as much as it is safe for the defense not to assume anything.
Yes, thank you, Your Honour. That was actually indeed the point that in analyzing a previous NSIS document from specifically the same period that the problematic paragraphs for my learned friend from the Ruto defense have indicated, December 2007, January 2008, that specific document, in the context of analyzing that specific document, an NSIS-generated report, the Chamber has clearly spelled out what they consider to be background information. In my understanding, there is no ambiguity in the definition that the Chamber has given to background information, including, the Chamber says, for example, the widespread nature of the attacks, election campaign activity, and the nature of what was being reported at that time. So if the prosecution confines itself to rely upon those documents within the circumscribed perimeter established by the Chamber, we don't see the reasons why these specific entries in this specific report should be excluded if we take and we analyze this document in the context of other similar documents produced at the same time by the same intelligence agency.
Ms. Bousman is worried about planning.
We do not intend to rely upon those documents to prove the common plan that is charged in this case. We intend to use these sections of this report for the widespread and systematic nature of the attacks and the contextual element of the charges. Therefore, this document, the way in which they are drafted, will be relied in this manner or for those purposes.
What about corroboration? Are you going to use the document for corroborative purposes in the sense of one of your witnesses or some of your witnesses testifying to certain events, and you're now saying, well, see, the passages we indicated in this document corroborate those stories told by the witnesses from the witness seat?
If the court allows the prosecution to use this material as corroborating evidence heard from witnesses, the prosecution will seek to use this material for corroborating purposes.
Is that the same thing as background?
The original intention of the prosecution was not to rely as corroborating. I did not mention it in the main submission. However, if the Chamber allows it, the prosecution will act accordingly.
Mr. Hooper makes the submission that this source of material is something that would have been better used as a springboard material from the basis upon which you go to find those or witnesses who will testify actually, to the offense indicated in the document. Now, that raises this question. This material, or these sorts of material, were received by the CPEV. Is it the case, there's a question, is it the case that what CPEV did was to say, we've conducted an inquiry, at the end of it, we have come to the conclusion that there's a need for a prosecutorial investigation to be carried on so that people may be prosecuted. Is that my understanding of what CPEV was about? If that is the case, assuming that is the understanding, correct me if I understood wrongly. But if I was correct in that understanding, is there some secularity then to jackknifing, as it were, to the material that the CPEV would have looked at to say there's a need for investigation so that there may be criminal investigation and prosecution? That's the second question.
Your Honour's understanding of the mandate of CPEV is, to my knowledge, correct. Another witness more appropriately placed to inform Your Honours specifically about the mandate is scheduled to appear soon. However, and it is correct that CPEV's mandate was to investigate the post-election violence with the aim at establishing the facts and identifying alleged perpetrators for possible judicial proceedings and eventually reparations to victims. However, the material that was put forward to CPEV in our submission is not to be excluded in terms of probative value, not only because material was put forward CPEV for the specific purposes that CPEV was, for which CPEV was created, does not mean that the material put forward is completely deprived of any value for subsequent judicial proceedings.
Those are my questions. You may complete your submissions in other respect then.
Subject to verification, with respect to the comment related to the parallel case in Kenya 2 and the comments on the statement by the prosecution that the NSIS reports were unreliable. I don't have the documents with me at this point. However, my recollection is that those documents presented in the other case were documents that were incomplete and there were sections that were missing. So the compilation itself of the document suggested that the document could not be relied upon. However, the information contained therein in the documents or the relevant sections that were contained in those documents, it doesn't necessarily mean, because the document was incomplete, that the information that was in the document was not reliable. Therefore, I believe there has to be a distinction to be made between the documents that were analyzed in the context of Kenya 2 And in this case, it was because the document, the way in which the document was put together in Kenya too, was not satisfying the minimum requirements of indicia of reliability.
You're saying you will need to verify what in fact was the position in the other case?
I would like to be absolutely certain of the context on this.
Make that verification and then inform us definitively of what the position was. Thank you. The Chamber will admit this document, and purely for background information, we mindful of the concerns raised by the Counsel for the Defense, we also are alert to our own responsibilities, and we hope to continue to be assisted by Counsel's submission on these things at the right time. The document comes in.
This document will bear the following number, EVD T OTP 00093, and will be registered confidential. It will also be referenced as prosecution exhibit number 93.
Thank you. Your next document, Ms. Zago.
Thank you, Your Honor. My next document is year and number CAN OTP 00061061.
What tab is it?
Tab 11.
Please proceed.
The document in our submission should not be displayed publicly. This is a roster of outpatients at the Nandi Hills District Hospital, which lists the outpatients by name, age, sex, and relevant diagnosis. I should mention that this document was...
Once more, this is a document that is coming in through this witness as material received by the Commissioner of Inquiry.
That is correct, Your Honor, yes.
And defense does not contest that.
Does not contest it, you're correct.
Mr. Kinkatwa?
We take the same position, Mr. President.
Please proceed.
The blinds then can come up and the document does not need to be displayed. The document, this specific list, was included by the prosecution in its original bar table motion. It was rejected by the Chamber, and I refer specifically to paragraph 75 of the Chamber's decision, because the Chamber could not fully assess the document's relevance or probative value, because the prosecution has uploaded only a redacted version of the document. However, today we intend to, and we are providing a complete, full, non-redacted version of this document.
What did we say about it in the bar table decision?
I'm reading from paragraph 75 of decision of 10 June at page 37, which says that document CAN OTP 006-1061 is indicated by the prosecution as a list of persons who were treated in Nandi Hills District Hospital. The Chamber notes that only a redacted version of the document appears to be registered in the case record. This has not been explained by the prosecution. The Chamber finds that it is unable to fully assess the document's relevance and probative value. For this reason, the Chamber does not admit the document. The prosecution wishes to tender the document, the same document, in its entirety, in non-redacted form, and explains that the reason why it was uploaded in the record of the case in redacted form was purely due to a technical oversight on our side. I should also advise the Chamber that a similar document stemming from the same hospital, containing a list of patients, was admitted by the Chamber, and the analysis of that document admitted and that list is at paragraph 74, the paragraph preceding the analysis of the document that we are analyzing now. The witness has explained that the markings of this document at the top right hand side, which reads Exhibit 62C, refers to a CPEF document introduced via Witness 62. The document, similar list of patients that were admitted by Your Honors in that decision bears the marking 62B, which we argue means that these two documents are stemming from the same witness and arguably from the same source. The information contained in this document is corroborative of information provided by other witnesses before this court concerning the violence in the district of Nandi Hills during the relevant period. And even if the document is not dated or does not appear to have a date, its connection to Witness 62 which was a representative of the medical services in the area is suggestive that the information had been assembled and prepared for the purposes of presenting it before CPEV, and CPEV had the mandate of collecting information and provide evidence to the Commissioner for the purposes of establishing responsibilities in the post-election violence. For all these reasons, we submit that this document should be admitted, has indicia of reliability, his probative value is established, and there is minimal prejudice to the defense. Thank you.
Mr. President, I have this document here in my hand, and I simply cannot see how anyone can rely on this document to make any finding. There's no name of a doctor, there's no explanation of a doctor, there's no identity, there's no ethnic group identified, we don't know how this list was compiled, we do not know whether these sort of reports were accurately reported at that time. We have no date. We don't have a reason for the injury. It could be the police. It could be anyone. This simply says nothing. I admit there's a limited prejudicial effect, but do we really want to? We want to keep a quality.
One second. You say there's limited prejudicial effect. What do you mean?
Because in our case, our case is whether or not our client himself is liable and responsible. So in that sense, it's not our case we're necessarily contesting this or not. The only issue I have is there needs to be, first of all, we need to look at the relevance. And if there's no relevance, then we don't even get to the question of prejudice.
1 second. My question is, when you say limited prejudicial effect, do you mean there is no prejudicial effect, or there is some prejudicial effect?
Of course, there's some prejudicial effect.
What is it?
This is not introduced for background information. This is supposed to present a list of names of people who were injured during that time, during the relevant time. We do actually not know who was responsible for these injuries, which group was responsible for these injuries. So in our view, this document demonstrates nothing. There's no relevance. If it intends to corroborate another document, it has no corroborative value. If that other document has the indicia of reliability, then that document can stand on itself. But this adds nothing. This adds nothing to you, the judges, and it adds nothing to the case.
You say there's no relevance. The document says on top of it, the title is Post-Election Violence, Outpatients, Nandi Hills District Hospital. And we have a witness who, you admit, came here, said he worked for CPEV as a records clerk, as it were, and who said that this was document received by the CPEV, and in this document that has the title I've read out, says name, age, sex, diagnosis, the columns we see on top. And you run down on the columns, on the column for diagnosis. First person indicated, number 1 there, cut wound. Number 2, trauma left eye. Number 3, soft tissue injury. Go down to 5, rape case, 6, rape case. Number 16, gunshot, and so on. You tell us there is no relevance.
Mr. President, what does this prove in respect of the case against Mr. Sang? I do not see that. I do not, as I said, there's no indication of how this list was compiled or who is responsible for these wounds. So on that basis, I'm afraid I don't see much relevance.
Thank you. Mr. Hooper.
First of all, we're very aware that the court has already admitted a number of lists, medical lists, in its decision. And bearing that in mind, my understanding is that this list is produced as background. That was my understanding. It's got certain deficiencies. We don't know who compiled it, from what records it was compiled. It was produced by Sipev Witness 62, who's a medical officer from Nandi Hills Hospital, we learned from the witness. But we don't know how this list came about. And more significantly, we don't know the temporal period that concerns this list, because you'll bear in mind the temporal period for the Nandi Hills crimes, as it were, is the 2nd of January, limited to the 2nd of January. And Your Honour's just done the exercise of going down that final column, the diagnosis. And I see Your Honour's point there. If you go down the names column on these 3 pages, it's very interesting, because the majority of names are, in fact, from my limited knowledge, appear to be Kalenjin names, Nandi names. As one can see with, there's even a Ruto here. No relation, but we've got clearly a majority of Kalenjins. So we're left with a document that may be admitted, but it remains rather suspended in terms of its use. And I bear in mind that, as I recall, the prosecution have already produced a list of people from Nandi Hills Hospital, which may be in conflict with this. And they're at some point going to have to tell us which list they're relying on, if they are. Those are our observations.
I imagine that might be something you would like to see.
Yes.
Conflicts in the prosecution evidence.
Oh, there's abundance of that already, but I mean, the more the better, yes.
Very briefly, this document, we argue that this document should be analyzed in connection with the other document that was admitted by the Chamber in the same context. The feature of the documents are almost identical. And if one follows the logic of the first document and import it in the second one, which is the one we are looking at right now, the first column seems to, the second column, titled OP number, seems to bear a date, a number and a date, 10/07. Sorry. The second column, the first patient listed, we can see a number 38910/07, presumably indicating the year of admission. And if we scroll down to entry number 9, patient number 9, we see a number of the patient 002/08, presumably indicating the year of admission.
Now you're speculating, are you?
I'm analyzing this document in connection to the other one and inferring that this is reasonably the system adopted to record the admission of the patients.
Well, just I hope helpfully, where does, for example, item 16, where do the numbers jump from 74 to 130? None of the numbers seem to bear any correlation. They're sequential on this list, but they pose their own questions, don't they, that numbering?
Well, I think we've had enough. The Chamber will admit the document. The document has prima facie relevance to this case in relation to the probative value. The Chamber will assess that in the context of the other material received in the case. The defense may, at the appropriate time, challenge any inconsistencies that they see in this document or in this document's relationship with other evidence in the case. But for now, the document comes in.
This document will bear the following number: EVD T OTP 00094, and will also be referenced as prosecution exhibit number 94.
Thank you. So, Ms. Zago, that brings us to the end of your document. Is that it?
Not quite. We have 3 more documents we would like to receive an MFI for.
And what are those?
And those are documented tab 7, year and number CAN OTP 0003 0522, titled Update on Post-Election Violence Deaths. This document was identified by the witness, and I don't believe there are any objections to that from my learned friends on the other side.
The document will be marked for identification.
This document will bear the following number: MFI T OTP 00095.
Thank you. The following number for MFI purposes is under tab 9, and the year-end number is CAN OTP 00059365, titled Status Report on IDPs.
Document will be marked for identification.
This document will bear the following number: MFI T OTP 00096.
The last document for MFI purposes under tab 10, year and number CAN OTP 0006 1045, titled Statement by Former Uasin Gishu District Commissioner before CPEV. This document, like the previous one, has been recognized by the witness as stemming from CPEV collection.
Document will be marked for identification.
The number assigned will be MFI T OTP 00097.
Thank you. I would like to place in the record that the witness was properly given warnings. I failed to advise the Chamber of that at the beginning of my examination. And with that note, I conclude the prosecution's examination in chief of this witness. Thank you.
You mean the witness was giving the Rule 66.3 and 74.11?
That is correct, Your Honor.
Right. Thank you for putting that on the record. A witness, we've come to the end of the prosecutor's examination in chief of you. We will be taking our morning break, but when we return, defense counsel, either Mr. Hooper or Mr. Keegan-Katwa, will cross-examine you. We will rise for 30 minutes.
All rise. We will level.